Okay. Hello, everybody, and welcome to the Geek Group. Tonight, I'm going to introduce our guest speaker. So tonight we have with us Kim Lisa Taylor, who is a nationally recognized corporate securities attorney, speaker, and the author of the #1 Amazon best-selling book, How to Legally Raise Private Money. She is the founder of Syndication Attorneys, PLLC, and InvestorMarketingMaterials.com, and has been the responsible attorney for hundreds of real estate securities offerings. Okay, with that, go ahead and take it away, Cam.
Okay, so tonight, first of all, thanks so much for inviting me to speak to you guys. I'm honored to be here. I think I know one person in the group, David. David. Tonight we're going to talk about legally raising private capital for your real estate investments. And it's my opinion that the way to be a successful capital raiser is to learn everything you need to know about it so that you take the fear away. The more knowledge that you have, the less fear that you have that you're doing something wrong. Every attorney starts with a disclaimer. This is for information only. There are no guarantees. The results depend on you. This is not legal advice, and we don't have an attorney-client relationship unless you have signed a fee agreement when engaged our firm. We would certainly love to talk to you about that if any of you are in that position, but we're certainly here to help if you need us. I am the #1 best-selling author of the book, How to Legally Raise Private Money. You can see it on the bookshelf behind me. I'll tell you later how you guys can get a free copy for yourselves. I am also the founder of Syndication Attorneys, PLLC. I founded this in March of 2016. Prior to that, I was a partner in a California law firm from 2010 to 2016. I actually started doing syndications as my focus of my legal practice in 2008. So I've been doing it ever since. I also have been a syndicator. My husband and I syndicated a 27-unit multifamily property in Columbus, Ohio, and we owned it for 9 years with our investors, and then we sold it in 2019. And I have a rental property right now, and then, of course, the property that I live in. I'm looking to probably start doing some more investing later on this year or next year. I used to be a property manager. I used to manage a 264-unit multifamily property. I'm a real estate broker, and then I'm also a certified capital raiser. I have been the responsible attorney for hundreds of securities offerings, helping people raise over $1 billion and buying over 300, so that they could buy over $3 billion in real estate. So we're going to talk today about what you need to know to legally raise private money. So I liken it to learning how to drive. When you're learning to drive, there's kind of 3 parts to it. You have to learn how to navigate. You have to learn how to follow road signs so that you don't get in an accident, and traffic lights and all of that. And then you have to learn how to operate the vehicle. So how to comply with securities laws is one of those aspects. So if you just kind of, we're learning how to comply with securities laws, how to split money with investors, and how to legally market your offering. And those are really the 3 parts that you need to understand. So we'll kind of cover most of those today. So how to comply with securities laws. The Securities Act of 1933 is still alive and well. It has been modified since 1933. But it was the first law that came out after the stock market crash, when it was determined that a lot of people had lost money by these unscrupulous solicitors of their money. They'd invested with them, and then they crossed state lines, hopping from one state to another. There was no overarching federal law that could make it a federal crime to steal people's money and defraud them out of their money. So the SEC was born. There was a series of these securities acts that were passed in 1933, 1934, and then in 1940. And so they all created the Securities and Exchange Commission, defined what are securities. Part of the hallmark of the Securities Act of 1933 is it stated that in order to use or solicit funds from investors, from private investors, you had to give them all the material facts so that they could make an informed consent about the investment and what they were investing in. So it kind of got rid of all the snake oil and people saw on the Brooklyn Bridge and swampland in Florida and all that stuff, because they had to disclose, if you're going to buy this land in Florida, it's a swamp, so that kind of eliminated that. And it also created penalties for violations. So what the other thing that it said that's relevant to what you guys are doing today, if you're going to be syndicating property, is that it stated that the offer or sale of securities must be registered or exempt from registration. So registered means you have to get pre-approval from regulatory agencies before you can even offer it to anybody. And exempt means that there are some exemptions that could apply in certain instances, but in order to qualify for these exemptions, you have to follow a certain set of rules. And there's different exemptions. Each one has a different set of rules. There's exemptions at the state level. So if you were buying a property in one state, all your investors were in one state, you're in that state, then you could qualify under a state securities exemption. So you'd look at every state has its own securities division. So think of it like a mini SEC. And they have all their own rules. So you could look up, for instance, what are the Indiana securities exemptions, and see if there's one that would be helpful for you to use if everything was in that state. If everything is not in the state, so when you start crossing state lines, you're buying properties in places that you don't live, or you're bringing investors from multiple states, then it really starts to make sense to use the federal exemptions. And the reason for that is because the federal exemptions preempt all the individual state laws. They supersede those, and they just say, if you follow the federal exemption, you don't have to follow all the individual state rules that might be conflicting or might apply for investors from all these different states. And instead, you just follow this one set of rules, but you are required to file a notice with the SEC, and then also what are called blue sky notices with the states where your investors claim residency. And a lot of people don't realize that these notices have to be filed within 15 days of when the investor's funds become irrevocably contractually committed. And that's always a matter of debate, is when does that occur? It should be stated in your offering documents specifically when that occurs, but certainly when you use the money and you can no longer give it back is going to be one of those things. But if it's not stated in your documents, that could happen actually when you receive the funds, which could be before you actually close on the property. So it's something you need to be aware of, because once those funds are irrevocably contractually committed and you wouldn't have to give them back, then you would be obligated to file those securities notices. And what if you then don't close on the property, but your trigger started before you closed on the property? Then there's fees associated with those filings, and then you've got to do rescissions, and it becomes a lot more complicated. So what's an offer? Well, an offer is when you're offering somebody something in exchange for their money. So, you're offering them some interest in your company, or you're offering them, a promissory note. So whatever it is that you're giving them in exchange for their money, whatever promise or agreement that you have with them, that is the security. And so that is an offer of securities. And then sale, of course, is when they actually pay you money for that. And again, when those funds are irrevocably contractually committed, then that's going to be that trigger. So what are securities? So in the world of real estate investing, the two things that apply are promissory notes and investment contracts. And there's probably others that apply in that list. So in the 1933 Securities Act, there is about a half a page full of all these different phrases and terms, and those are the things that are securities. But the ones that pertain to the real estate investors, the very first one in the list is promissory notes, and the second later on down in the list is something called an investment contract. So what is an investment contract? It's an investment of money in a common enterprise with an expectation of profits based solely on the efforts of the promoter. And this was actually decided in a Supreme Court case that took place in 1946. Actually happened in a place in Florida called Howey in the Hills. It's a little town where there were a bunch of orange grove operators. And during at that time, prior to 1946, when this whole case arose, the Orange Grove was offering people to invest in the orange grove, and they were saying, you can invest with us, and we're going to continue to harvest the oranges, and then you can, reap the profits. We'll share the profits with you. And then at some point, they decided they don't want to do it anymore, and they sent letters to everybody saying, we're going to stop doing this. We're not going to harvest the oranges and share profits with you anymore. Here's your tree. Here's your plot of land. And the people complained, and they said, that's not what we bought. We bought an investment contract. Prior to that, the term investment contract hadn't been clearly defined, but out of this case, which eventually made its way to the U.S. Supreme Court, came this definition. So when you have an investment of money in a common enterprise and an expectation of profits based solely on the efforts of the promoter, then you are definitely in the realm of selling investment contracts. So just another way to say that is when you have passive investors. So any investment with passive investors. And I noted in the last slide that promissory notes are securities. A lot of people don't realize that. But if you're in a business that depends on your repeated borrowing of money from private individuals, not from hard money lenders, but if you're borrowing money from your friends, your family, acquaintances, people at your real estate investment association meetings, ordinary people with some savings or self-directed IRA, if you're in a business that depends on that repeated borrowing, then you are engaging in the sale of securities in the form of notes. And so you too would have to follow these securities rules. All right, so here's some examples. LLC interests, limited partnership interests, corporate shares or stock, any kind of a passive investment. So what is a syndicate? Well, a syndication is just organizing a group for a common purpose to promote a common interest or to carry out a particular business transaction. So it's just everybody's pulling resources. Some of you have knowledge, some of you have money, putting that all to, some of you have contacts, some of you have the ability to guarantee a loan, all of those things coming together for a common purpose for the group. So what's the difference between a syndicate and a joint venture? Well, in a joint venture, you have an investment of money in a common enterprise with an expectation of profits, but the investors are responsible for generating their own profits. They are not passively involved. They're actively involved in generating their own profits. I do see a very common mistake is that people frequently advertise for joint venture partners when they really want passive investors. And they think, well, if I call it a joint venture, then I don't have to follow securities laws and it's less expensive and less cumbersome. But it's not what you say, it's what you do that's going to determine whether or not you sold securities. A securities regulator, a former securities commissioner, was once asked at an event, how many time, what percentage of the time, if somebody asks you if something is a security, or do you find that it's a security? And he said 95% of the time. So, if it walks like a duck and quacks like a duck, it's probably a duck. Yeah. So here's the problem with joint ventures. You got too much stuff going on. You have too many people trying to make decisions. Everybody has to agree. So it only works for about 5 people or less. And I say that out of all these years that I've been doing this, I've seen many, many times when people have tried to put joint ventures together with more than 5 people and they have not gone well. So and joint ventures can take place in a couple of situations in a real estate transaction. You can use a joint venture to go ahead and buy something directly, or you can use a joint venture to be the management of a syndicate. So to be the manager of a syndicate. And in either of those cases, more than 5 doesn't work in a joint venture, in my opinion. I've just seen too many times that it went wrong. The worst case scenario ended in litigation immediately after they closed on a multifamily property. So there's 3 types of securities offerings. There's registered offerings. So those are the ones that are pre-approved by the regulators. That's a public offering. That's, going public with your company, doing an initial public offering. All that is related to the registration of those securities. Exempt offerings, and then there's illegal offerings. So exempt, again, means that you have to follow a specific set of rules. So who doesn't follow securities laws? There's 4 kinds of people: those that don't know, those that don't care, those that are in denial, and those who are in jail. And there are a lot of people in jail for securities fraud or securities offerings, illegal securities offerings. So it does happen. It can happen, but you don't want it to happen to you. I meet a lot of people who are in denial. You know, I have run across this one person probably 5 or 6 times over the entire years that I've been doing securities. And she keeps coming back and, you know, somebody will say, oh, you know, well, I just met this woman and I told her she probably should talk to you. And then I'll talk to her and I'll say, what you're doing are securities. And she goes, well, you're like the 5th person that's told me that, but I just don't believe it. You know, it's like, well, some people can't be helped. All right. When do you need to follow securities laws? So if you're going to be raising money from private investors, and you're selling interest in a company to passive investors, or you're repeatedly borrowing private money. So what does it mean to follow securities laws? You either have to register your offering or choose an exemption, and then you have to document how you complied with the offering or with the exemption. These exemptions are self-executing. Think of them like tax deductions, right? When you're taking a tax deduction, you know, it's between you and, you know, your CPA, or maybe you're doing them yourselves and you're putting, you know, checking a box on a form saying, oh yes, this applies to me. I am entitled to take this exemption. If you get audited by the IRS, then you have to show them the documentation to prove how come you're entitled to that exemption. If you can't show them the documentation, then they're going to take it away. They're going to, you know, you're going to have to pay some penalties and some interest for not paying the correct tax in the first place. So securities exemptions are the same way. They're self-executing. You're going to, you know, state that you are following this exemption. You're going to file those securities notices claiming that I'm following this particular exemption. These are the rules I'm going to follow. And then if you're ever audited, so how would that happen? That would happen if somebody complained about you to a securities regulator, or if you got in litigation with an investor. And in that case, if someone complains about you to a securities regulator, they're going to send you a letter and say, you know, we want to see all of the paperwork related to this particular offering. And they're going to ask, you know, you and everybody on your management team and everybody to provide them with all that documentation. And then they're going to decide whether they see sufficient documentation to prove that you did comply with the exemption. If you're in litigation, it's going to happen through discovery. And the reason for that is because the attorney that's hired by the investor is going to be looking for ways that you might have broken the law that they can use as a leverage to get you to give back their investors' money, or maybe everybody's money. So, you know, one of the penalties that could apply if you don't follow securities laws is you could be forced to do a rescission where you have to give everybody's money back within 30 days. Well, that's very hard if you've already bought a property with it. You can't do it. You know, you'd have to go out and you'd have to re-syndicate it legally and raise that money, and trying to do that in 30 days would be very, very difficult. Other penalties are, you know, you can have $50,000 a day fines for non-complying with securities laws. You could also be prohibited from ever engaging in any kind of money-raising activities in the future. Let's talk about these securities exemptions. So typical securities exemption rules, and remember, they could be at the state level or the federal level. At the state level, they might limit the dollars that you can raise. They might limit the number of investors, or have certain limitations on the number of investors that meet certain financial qualifications. They might have financial qualifications for who even can invest with you and what kind of net worth they have. At the state level, you'll often see things that say that they can't invest more than 10% of their net worth, which requires you then to look at how much net worth they have. Or they can't invest more than, you know, 10% of their income or something, you know. So there's going to be some limitation at the state level that not necessarily at the federal level, but those definitions are a little different. We're going to cover them in a minute. You might be able to not be able to advertise at all, or you might be able to have very limited ads where, you know, they dictate what the ad looks like. And by the time you get done with it, it just looks like a piece of paper with a bunch of words in it. It's not very exciting. They're all going to require that you disclose all the risks of the investment to everybody who's thinking about making an investment with you. Again, you always have an obligation to provide all the material facts that investors need to make informed consent. And that's always an obligation. So even if you find something during your due diligence after you've already raised money, or you now have to add that to the risks that your investors are aware of. And then you usually have to file some kinds of securities notices. So the investor qualifications for a Regulation D Rule 506 is the exemption that most people use at the federal level. There's two options under Regulation D Rule 506. One is Reg D Rule 506B. The Rule 506B allows you to raise an unlimited amount of money from an unlimited number of accredited investors and up to 35 non-accredited but sophisticated investors. But you can't find them through any means of general advertising or solicitation. And the way to prove that you didn't advertise is to be able to demonstrate that you had a substantive pre-existing relationship with those investors prior to making them an offer to invest. Pre-existing relationship means that you knew them before you made the offer to them. A substantive relationship means that you knew whether they were accredited or not before you made that offer, and whether or not this investment was suitable for them. So accredited means someone with $1 million net worth, excluding any equity in their primary residence. Or they have to have $200,000 a year if they're income, if they're single, or $300,000 a year income if they are married or married equivalent couple. And then there's other definitions that apply to entities. So for instance, any LLC whose members are all accredited or that has over $5 million in assets can also apply as qualify as an accredited investor. If you had an entity that didn't have all accredited investors, then you would have to count these non-accredited investors towards your 35-person limit if you were doing a 506B offering that actually allows you to bring in those sophisticated investors. What's sophisticated? Well, that's people who aren't accredited, but they have to have more than just some savings and a job. They have to have some background, financial background, education, or experience that would allow them to understand the merits and risks of the offering and make sure that it's appropriate for their portfolio. So these are things that you want to learn before you start making offers. The alternative to Regulation D Rule 506B is something called Regulation D Rule 506C. So Rule 506C allows you to advertise freely, but you can only allow verified accredited investors to invest with you. So they actually have to go through a verification process, where for 506B, they can self-certify. You give them the definition, they check boxes and say, yep, I meet this. And then there's usually a questionnaire. You're going to ask them about their level of sophistication, what things they've invested in, how many other things they've invested in, etc. So those are important things that you really need to know and understand if you're going to do securities offerings. All of our clients start with Reg D Rule 506B offerings. Some of them never go beyond that because most of them know sophisticated investors that would be fine investors that they can bring into their deals, but not everybody only knows accredited investors. And until you have a significant track record with the type of asset that you want to buy, you're not going to be able to attract strangers to your deal, because the first question any stranger is going to ask you when you advertise for them is, how many have you done before? So if you haven't done any, then you have to have someone on your team that has a significant track record with the same asset class and other syndications, acquiring those assets in order to be successful in an advertised offering. So, your friends and family and acquaintances, they'll invest with you before you have a track record. They'll help you build that track record. It's the accredited investors that you're advertising for that are going to want to see that track record. So, most people, many people never go to the Rule 506C. And according to the SEC, even there's about 25,000 Reg D Rule 506 offerings the Form D is filed with the SEC, but about 90% of them are still Reg D Rule 506B, and the median raise is about $1.5 million with 14 investors. So don't think, oh, I'm not raising very much money if you're only raising $1.5 million, because that is the median raise of all those 25,000 offerings. So All right, so what defines the relationship? We talked about that a little. So the substantive means you have to determine the investor's suitability and their financial qualifications before you actually make an offer to them. So that means that if you are thinking about doing securities offerings and you don't have a deal right now, you really need to be going out to all the people that you know and having a conversation with them about their suitability and whether they're accredited or not accredited. And if they're not accredited, how might they be sophisticated? And you have to have a database where you keep note of all that information and when you learned it, because when you learned that is the point at which the substantive relationship is established. From that point on, you can make direct offers to them of specific investment opportunities. Prior to that, you really can only talk to them in general about what your company does and the kinds of things that look, kind of returns it offers and just very general information, nothing specific about a property. Okay, so how do you split money with investors? So we talked about what a joint venture and the distinction being that you had to be actively involved. All the members had to be actively involved. In the eyes of the law, when you create a member managed LLC, that's the typical structure used for a joint venture, then all of the members are considered to be managing members legally so that they can all open and close bank accounts, bind the company legally. So you have to be careful in a member managed LLC who's on your team and making sure that you understand, what their rights and obligations are. So that's a joint venture. So again, not good with more than 5 people. And then a typical offering to buy, let's say, a multifamily property, which is what the bulk of our clients do, and it seems to be the most freely traded asset class, are multifamily properties. So you would create, or we would create for you, a manager-managed LLC. So when you're forming an LLC, you have the ability to check, is it managed by members or is it managed by a manager? If you're, say, managed by a manager and then the members are contributing cash, and you're going to be the manager, well, you've just created that investment contract because you're the manager, you're the one running the show. They're not. They're just investing money. So just by creating a manager-managed LLC, you've created a security if those investors or if those members are contributing cash. So we usually do a 2-class structure. So class A is going to be all cash paying investors, including the members of the management team. And then class B is the members of the management team. And that's the portion of the profits that you're going to carve out for yourself and the portion. So usually you're going to sell off some of the ownership interests in that company to your cash paying investors, your class A, and then you're going to keep a portion of it for class B from the management class. And that's where you're going to earn your bulk of the profits as a syndicator. Okay, so this venture structure, okay, so we talked about the fact this is a manager managed LLC. Well, the manager itself is a separate LLC. And we want that to help protect your assets and the assets of your management team so that if you are sued by investors, then you have one additional layer of protection between them. And we also want that instead of having you named individually as the manager of a syndicate, because if you have 3 or 4 people that are named individually as the manager of a syndicate and then all of a sudden they can't get along, then you want to get rid of somebody, well, now you have to involve the members. But when you have a manager LLC, then as long as that manager LLC stays intact and continues to operate and manage the investment level company, then you don't have to involve the members in any drama that goes on at the management level. And I can assure you that that's where it happens. Okay, so who earns what? So the manager earns certain fees and a share of cash flow. So some portion of the profits and then a share of the sales proceeds. So after you pay off your expenses and your bank loan, then whatever's left gets split between the manager or the Class B members and the other investors. All right, so the investors just earn a share of cash flow and a share of sales proceeds. But let's talk about what kind of fees the manager can earn. So acquisition fees are typically 1 to 3% of the purchase price. Actually, could be up to 5%. On the smaller the deal, the higher the acquisition fee. The larger the deal, the lower the acquisition fee. You get into a $10 million deal, you're not going to be taking a 3% acquisition fee. You're probably going to be taking 1 or 2. But if you're doing a $300,000 deal, then you're probably going to be doing a 5% acquisition fee, because it's almost as much work to do a small deal as it is to do a big deal. In fact, sometimes there's more risk in doing small deals than there is in big deals, because in the small deals you have to do personal guarantees, and in the big deals you can get non-recourse loans. So it's just you add a zero. It doesn't really take that much more effort. The documents, unfortunately, because of the way these rules are structured, it doesn't matter to the SEC whether you're raising $200,000 or if you're raising $2 million. They want the same level of documentation that they would, and securities compliance that they would, even if you were raising $2 million or $200 million. So it's a little bit, it's not favorable to the small investors. So you can get refinance fees. You can also get disposition fees. You can also get a share of the cash flow from operations, the period of time that you own the property, and you're splitting rental income, after expense rental income, and the share of the sales proceeds that we mentioned before. So what's in a securities offering? Usually you're going to have a private placement memorandum, which is a disclosure document that's going to describe all the risks of the investing. The ones that we write for multifamily have about 7 pages of risks. So you're going to have risks related to real estate, risks related to taxes and the way the company is structured, and then risks related to that specific property. Usually going to have the securities compliance documents are the PPM and the subscription agreement. So PPM is where you're telling the investors about the investment. All the different things could go wrong. The subscription agreement is where they're asserting to you they've read all the documentation you've provided, they understand the risks, they meet the financial qualifications, they can afford to lose the money, and this is how much they're going to invest. So that's what the subscription agreement is about. And then it has an offeree questionnaire where they're actually going to have to answer some questions about their level of sophistication. The operating agreement, I kind of call this like a sandwich, right? You've got the PPM, you got the subscription agreement, but right in the middle of it, you got the operating agreement. And that is the contractual agreement between you and investors. And that's the thing that goes to court. If somebody is complaining that you're not following your operating agreement or you're breaching the terms, then that's the thing that's going to get litigated. So you'll also have an operating agreement for the manager LLC and a separate LLC for that. That's not listed here. But then attached to your offering package, so we've got these 3 legal documents, the PPM, the operating agreement, or it could be a limited partnership agreement, but not very often. We usually don't use limited partnerships unless you have investors from Canada or from some country where a limited partnership would be more advantageous to them than an LLC. And that's usually based on what the tax treaty between our country and their country says. But the fourth thing that comprises your offering package is something called an investment summary, or I heard one of you mention earlier that your property package. Those are really the same thing, where you're describing in plain English as a standalone marketing piece what you're buying. And you're talking about where it's located. You're showing some pictures of it. You're going to talk about your business plan for that property. What do you plan to do to it to make it operate better than the person who had it before you? And you're also going to have 3 tables in there that are critically important. One is called the sources and uses of funds. Where are you getting the money to buy the property? Part of it usually going to be coming from a bank loan, could also be coming from your investors, and maybe even from a seller credit. So those are the typical ways you're going to get the money. You might even be getting some tax credits in certain situations. So those are the sources of funds. And then how are you going to use those funds? So you're going to have your down payment, your closing costs, your any kind of lender required reserves, your acquisition fee, any legal fees, your organizational expenses for forming these companies and all of that. So all of that plus your capital improvements, and then you're going to want to set aside some reserves. So you're going to add all that stuff up, and it has to equal the sources of funds and the uses of funds have to be equal numbers. And usually when we do a securities offering, we actually do what's called a minimum maximum offering. So with the minimum is going to be the minimum amount you would have to raise to just squeak by and close on the property, but you can continue raising money after closing in order to get all the funds you want for your capital improvements and your reserves, and to pay yourself your fees and to reimburse your pre-closing expenses, all of those things. And then you need to have a pro forma. So what is your pro forma for 5 to 7 years, however long you plan to keep the property? And then what is your proposed exit strategy? What are you going to do? How are the investors going to get their money back? What do you think the property might sell for? And then you're going to have to write a list of assumptions that accompany those 3 tables and that explain what it is that, what assumptions have you made? Because the reason for that is because we can write into the documents that you've made certain assumptions based on your best information at the time. And it could turn out that your assumptions are completely wrong because you can't predict the future. So then you have securities notice filing. So those first 4 bullets comprise your offering package. And that property information, that's actually the same thing. But you might have like a pitch deck or something like that where you're actually have a little PowerPoint presentation. So you're going to have 2 different versions of that. One that's going to be like more of a written version that somebody can sit down and read through on their own time. And then you might have a pitch deck that's more like the slide presentation I'm doing for you, where you got a bunch of bullet items that you're just kind of hitting and highlighting as you go through and you explain what the offering details are. All right, so how can you legally market your offering? Well, as we've talked about what you need the money for, but you can market it to family and friends. So that's the Regulation D, Rule 506B exemption is the family and friends exemption. I can't tell you how many times people have come to me and said, well, I'm only raising money from family and friends. So I don't have to comply with securities laws. And it's like, well, you're wrong, because there is a family and friends exemption. It does have specific rules. You do need to follow those rules in order to get that exemption. There isn't just a family and friends exemption that says you don't have to do anything. There's, Reg D Rule 506C, that's sometimes called the crowdfunding exemption. That's the one where you can advertise, but you can only have verified accredited investors. But then there's also people that employ illegal capital raisers. I get a lot of people that come to me and say, well, I'm a capital raiser. How can I do it legally? Well, the answer is you can't. You can, as long as you don't want to get compensated for it. Right. So if you want to get compensated for it, that's where the complication arises, because the securities laws say that the only people that can legally raise money for you and get compensated for it have to have securities licenses. And the specific securities license they have to have is a broker-dealer's license. And that's not easy to get. It's very, very difficult to get and very expensive, and it's very hard to maintain. And then once you do that, then you open yourself up to all kinds of regulatory scrutiny. So it's very hard to be able to compensate people for the amount of money that they brought to your deal. So how do people do it? Well, so what you have to do is you can admit people to the management of your syndicate, but their compensation cannot be based on the amount of money they've raised. Any compensation that's based on the amount of money raised is called transaction-based compensation, and that is specifically what's illegal. So any formula that you're using that says, oh, he brought in $300,000 or she brought in $500,000, and this is, what percentage of the manager they get and what percentage of the Class B interest, that's going to fail if you're ever scrutinized by a regulator or in court. Because at that point, then they're going to ask, how was it determined how much that you earned in the management? And if anybody says, well, because of how much money I raised, that's the wrong answer. So then you lose your exemption. They could be charged with a felony for acting as an unlicensed broker. They could also be held responsible for that investor's investment for the entire time that money is invested. So anybody who's illegally acting as an unlicensed broker. can have some pretty harsh consequences. So not something you want to do. And also realize that anytime you violate securities laws, there's always the chance you could be prohibited from ever being involved in securities offerings again. So what's illegal then? Paying unlicensed brokers. So you lose your exemption because each of the exemptions at the state level says that you won't pay, that you get the federal exemption in their state as long as you follow all of its rules, you file the required notices within the 15 days, and you don't use any unlicensed brokers to raise money for you. And so when you get in trouble, if you're getting in trouble with a regulator, it's probably not going to be the SEC. Because the SEC, as near as I can tell, doesn't go after anybody that hasn't stole $15 million or more. But the state securities agencies do. And not only, and the state securities agencies, they don't have big budgets to go out and, bust people and all that, but they certainly have a lot of time to surf the internet, looking for illegal offerings, attending, virtual conferences, things like that, just to see if people are doing things illegally. So you want to be really careful about that. Paying unlicensed, don't pay unlicensed brokers, don't pay commissions, don't hire independent contractors, consultants, or liaisons to raise money for you. And anybody that says they can raise money for you, make sure that they have a securities license, or you actually want them on your team, and they're going to have some meaningful job in management other than raising money. And that really is what the rule is. The rule is that everybody in management should be raising money. Nobody gets compensated for the money that they raise, but they all have another job, and that's what they get paid for. So make sure that you give all the people in your management team jobs. I have known someone in the past that had 16 people in the management of their team, and they came to me and said, how do I make this legal? And the answer is, I don't know. But yeah, good luck with that. I can't help you, because you don't have 16 jobs to give to people. All right. So if you want to be successful as a syndicator, you need to have an investor marketing plan. And your investor marketing plan, and that's what that book I mentioned earlier, the one-page marketing plan should entail. It should answer all of these questions. How are you going to meet investors? What are you going to say to them when you meet them? So what's your elevator pitch or your magic statement or whatever you want to call it? How are you going to make a lasting impression? So that's usually by having something that you can give them. And maybe it's a business card, but really it should be more than a business card, some kind of a company brochure or, a postcard or something that they can take home and share with their significant other who hasn't met you and, helps them remember who you are. And then how are you going to stay top of mind? How are you going to get them to remember who you are if it's 6 months between when you met them and when you now have a deal? And you're usually going to do that through a newsletter, or if you have local investors who live locally to where you are, then you're going to host meetings. And what Max is doing, he's hosting meetings and meeting people. And I don't know what his objective in doing that, but you could certainly do something like that with your own investors. Okay. And then, what will you give investors to take home to remember you? So, you've got to think about branding. Branding is important. I spoke to somebody today who said, oh, I got a letter from some other investor, or I got a letter.
I'm sorry to interrupt, but just watch your time. You got about 5 or 10 minutes left. So I apologize.
We are almost done. So.
Okay, thank you. Sorry for that. Thank you.
No problem at all. But I talked to somebody today that actually said they got a letter from a company saying, oh, they said it was a friendly letter, luckily for them, who said, you have a website that has a name that's really close to our name, and we're a public company. We have $500 billion, and you and you don't. So you might want to change your name. So, I've seen that happen a couple of different times. You don't want to get in a fight with people that have established companies with similar names. So you've got to be careful about how you brand and what your domains are. Just because the company name is available in your state, you should also be doing a Google search and a domain search and finding that domain. And if you're finding that somebody else already has the domain that's your company name, then that's probably not a good sign. You might need to think of something else. But anyway, you do need an investor marketing plan. This is probably the most important thing you can do if you're starting out as a syndicator and you haven't already established a database of prospective investors. That's your goal. It's establishing a database of prospective investors and continuing to grow it over time. Okay, so what kind of marketing tools will you need? Investor marketing plan, company brochure, website, some kind of a property overview or a property package when you have a deal, pitch deck. So those are the kinds of things that you might need. So how can we help you? We do syndication attorneys does securities offering documents. We also create joint ventures. We'll form companies. We do have something called a pre-syndication retainer, which is for people who want a securities attorney on their team, but they're not ready to syndicate yet. And then with that, you'd get invited to our weekly masterminds. We hold them on Friday mornings. I host those, and it's clients only. It's just a great opportunity to talk to other people that have the same questions you do, or can answer the questions that you have, and then just kind of help you further your business and further that investor marketing plan. At syndicationattorneys.com, if you would like a free digital copy of my book, How to Legally Raise Private Money, you can get it there. Just click the Get the Book tab. And then we have an affiliate company called investormarketingmaterials.com. So that's all I've got.
Nice. Okay. And thank you. And I'm sorry to interrupt you. And we're always pushing on time here. The members who are on the call, do you want to raise a hand? There you go. Oh, okay. Trina says great presentation. Thank you, Trina. How about a quick question or two? It's 19 after. We got 11 minutes.
Happy to take questions.
I got a question.
Sure. Hey, David.
So, so I just picked up on something when I heard this presentation. I heard you give this presentation before, but this just stuck with me. So if I understand correctly, even if you, so it's illegal if you, so say you're raising private money for, say, for example, like a single family home, and they're going to take second position, that's legal, or you still need like a license for that as well?
Well, it depends if you're doing an isolated transaction or if your business depends on you repeatedly soliciting investors for these second position loans. So I would argue if you're repeatedly, borrowing money from private investors, then you should be doing it depending on the investor's qualifications. First, you should find out, is it going to be fall under state exemption, or are you going to have to follow some federal exemption? You've just learned what the federal rules are. You would have to then determine whether those investors are accredited or sophisticated. Make sure you have a private placement memorandum and a subscription agreement.
Got you. Okay.
Right? If it under state law, there might be some exemption that would allow you to do it as long as you're doing it all in one state. So the investor in the same state where the properties are and where your company is.
Okay. I've also seen investors here in California where they would have like a flip project, and they would, so, first position would be the hard money, and then second position that would be the private money, but then they would have people split the second position. So they might need, say, 150,000, and then 3 people each put in 50K. So that's illegal?
So I am licensed in California and Florida. I am able to help people in any state because most of what we do is under federal law. But I am familiar with the California rules regarding that. And in that situation you described would require that that solicitation was done pursuant to a securities exemption, either at the state or the federal level. And so there's actually some forms that you need to fill out and send to the state, telling them which exemption you're using. There is a state exemption. I can't remember the exact rules, but it was something like if you do it to only accredited investors and no more than 20 investors in a year or something like that, there's some exemption that might apply. But you still have to know what that exemption is and still make sure you're following those rules. Because just having one non-accredited investor could mean you didn't follow the exemption.
Okay.
Mm-hmm. Anyone else?
Anyone else? You can raise a hand down in the menu bar or just open your mic.
Kim, this is Larry. I've heard this term Class A, Class B before, but it seems to have different definitions on different deals. Is that are these just generic terms or
Well, everybody's going to have their own definition of what it is. I mean, you know, we write the offerings the way we do, and we have for a very long time. I've seen a whole lot of other offerings written this way, but you know, it doesn't mean somebody else couldn't be applying it in a different way.
Okay, thanks for that. I was just concerned that maybe they weren't following rules. Yeah.
No, that's not a legal requirement. You know, you can structure a deal as many ways as you can slice a pie, right? You know, any way you can think of. So it's just very typical that there's going to be some carve out for management and there's going to be something sold to investors. But for instance, you know, we often do subclasses of Class A, where Class A1 is going to be some fixed return class, and Class A2 is going to share in equity. So you can do that as well. But I've also heard other people say, well, we just call them Class A, B, C, D, E, you know, so it doesn't matter. You know, we just, for a perception issue, we think it's a better perception, not that your investors don't want to be Class B, right? So we do the subclasses.
Okay, that's awesome. Okay, anybody else? So I have one. If nobody else, I don't hope I'm not cutting anybody off. So also, Kim, now a real estate attorney who litigates, would that fall under your firm too, or would that be a separate attorney as opposed to an SEC attorney doing the work you do?
No, that's a really good question. In fact, on our website, there's a very, very extensive library where we have over 50 different articles on all different aspects of syndication. We've got frequently asked questions, and then we also have a podcast called Raise Private Money Legally. But that is one of the questions that was raised in one of our articles, is what's the difference between a real estate attorney and a securities attorney? And the difference is, so there's a real estate transactional attorney, and then there's a real estate litigation attorney, and those are also different people, right? So the litigator is the one that's going to defend you in court or prosecute you in court on behalf of an investor. The real estate transactional attorney is in a syndication context, they're going to be the one who helps you set up title and escrow. Closing attorneys are required in some states. They're going to help you review the loan docs. They'll help you with the purchase and sale agreements and your property management agreement. Where we're only dealing with the part of setting up your company. So we're corporate securities attorneys. So we're setting up your companies and we're helping you comply with securities laws. So we would be working hand in hand on a multifamily transaction with your real estate attorney. We don't do the real estate law because we believe that the real estate law is something that should be done by an attorney that's licensed in the state where your property is located, whereas we're operating under federal law, so it doesn't matter where we are, the rules are the same. So we're able to help you with the money raising part. So we would work hand in hand with your real estate attorney, getting the lender all the information they need about your companies and your organization chart and how all of that is structured, so they get the information they need to do the close.
Excellent. Thank you for clarifying that. And just one last, it doesn't sound necessarily like it, but possibly do you have referrals for real estate attorneys / litigating real estate attorneys?
We do. If you look at our, well, again, so the real estate attorneys, we have limited. You know, if you call and ask me, hey, do you know a litigation attorney in California? I could tell you, you know, I could give you one. Know them in all states. I know some transactional attorneys that have done good work for some of my clients in some, you know, several states, but I certainly don't have an exhaustive list for all of the 50 states. But I can help guide you into which kind of attorney you're looking for your specific situation.
Sure.
We do have a resources page on our website, so if you go in there, you'll see some of our trusted referral sources.
Excellent. Thank you. Okay, so I apologize. I hope I'm not cutting anybody off, but you have contact information on the weekly document for Kim. We have 3 minutes left, so will everybody unmute that's still on and go back to the weekly document, scroll down to the bottom, and let's rate and wrap. Remember, you're not rating the speaker, you're rating the meeting. And remember, the rating system works like this. If you're rating an 8 or an 8 through 10, you don't need to make any comment. If you're rating a 7 or below, please make a comment. The point of the rating is for you to voice anything that's on your mind. Even though we may not be able to solve it right now, at least we can get back to it later. You just don't want to be in a situation, this is, Kim, this is from the Traction book, we use their system. You just don't want to be leaving a meeting, you know how you leave a meeting sometimes and you didn't get to say your piece, and then it just burns you for the rest of however long that is. So that's the point of this rating system, and that's what we're working on.
Well, I would encourage you, if you have some questions that you're just, shy about asking in front of the group, do reach out to me. You can, if you want to schedule a free appointment with one of our staff, you can do so at syndicationattorneys.com. You can schedule a call there. And if your question is something that I need to answer, then they'll get you in touch with me. But we're always happy to answer and happy to work with you. But check out our website. There is a plethora of resources there for you. I create them for people just like you. A lot of our clients have never done deals before. And we want to handhold you through this process so you gain the confidence and you can go on and do it again and again. And David, you've been on some of our masterminds,
Yeah, the masterminds are better because it's not recorded. So you can...
We don't record.
Okay, is everybody unmuted? Justin, go ahead, read your rating.
I gave the meeting a 9.
Thanks, Sarah. Trina?
9.
David?
9.
Pedro?
9.
Larry?
I'm giving you guys a 10 tonight. I just, I like Kim.
Thanks,
Yeah, remember, you're not rating the speaker, but the meeting, so that's
And I like you too, Matt.
So I'm giving it a 9.5. Darnell?
9.
Star?
I'm giving it a 9.
And anybody I missed that's still on, if you want to holler out your name and your rating.
Charmaine, 9.
Thanks, Charmaine. Anybody else?
So I want to
Okay.
know what I have to do to get a 10.
Yeah, and that's a good question. What is the speaker, not the speaker, what would the meeting have to be to get a 10? It's an absolutely good question. And it's part of the Traction feedback too. When you sit around in your Traction weekly meetings and you're not giving 10s, you should be asking yourself, what could have happened during the meeting that would allowed you to have rated it a 10? And that's all part of the feedback process. And so I want you to employ that in your individual team meetings. And with that said, we're at 6:30, and one of the immutable laws of these meetings is we end on time. So I want to say goodbye to you all. Thank you so much to Kim, and thank you to you all. Happy Thanksgiving to you all, and I appreciate you.
Bye-bye.
Thank you.
Take care, guys.
All right, bye. Everybody have a great weekend.
You too.
Bye, everybody.
Thank you. Thank you, Ken.
Thank you. Bye, everybody. Have a good weekend.